First of all, bail is premised on the presumption of innocence. The Constitution provides that each person accused of an offense, however grave, is presumed innocent until either they plead guilty or they are proven guilty. So every person has a constitutional right to apply for bail. It's a right to apply. Many people mistake it that I have a right to bail. The bail is at the discretion of court. So every person has a right to apply. So if you are an accused person and you're presented before court, the first question is whether that court has the jurisdiction to grant the bail. The nature of offenses is such that for those offenses which are triable by the High Court, it's only the High Court which can still grant the bail. So even if you're presented to the Magistrate's Court for remanding or for the reading of the charges, you cannot apply for bail in that court. You can only make a formal application to the High Court. But if you are presented in a court which has the jurisdiction to grant the bail, then you can apply either through your lawyer if you are represented or directly by yourself. Most importantly, bail is the discretion of the presiding judicial officer, either the magistrate or the judge. And all other, either the Chief Justice guidelines or the guidelines under the law, both under the Magistrates Courts Act and the Trial and Indictments Act, they are only guidelines. They are not mandatory that the judicial officer has to or follow them by the letter. Bail is at the discretion of the presiding judicial officer, ultimately. That is why there is no law which sets terms that for this offense you are supposed to give these terms. So all those things which have been developed by practice, for instance, the accused person bringing substantial sureties, they are largely guidelines. The judicial officer even has the powers to dispense with them. Court even has powers to release you on its own cognizance. That means that court can release a person even without sureties, even without any form of identification, if the judicial officer has appraised themselves that this person will be able to come back. Because at the bottom of it all, bail is an agreement between the accused person and the court that I will appear every time I'm needed until the conclusion of this trial. So the person can bring substantial sureties. When we talk about substantial sureties, we mean those people who can have control over you to ensure that you return and attend your trial until conclusion. That means that you're supposed to bring people who ordinarily have some bit of power and control over you. And that goes to the substantiality. Because if you bring people who are under your control, then that means that those people may not be able to prevail over you to return when court needs you. So the substantiality test goes to those people who have the control to ensure that they can compel you to come back to court till conclusion of the trial. And of course, court is supposed to appraise itself with their documentation, where they stay, possibly where they work. That's why there's a requirement for LC letters, introduction letters, maybe employment, maybe national IDs. That is supposed to go to the root of identification. Will these people, can I trace them when we need them? Then secondly, the terms set are also at the discretion of court. There are no set terms. When the state attorney is opposed, still the ruling is up to the court. Yeah, the court can agree with the state attorney, or it can disagree with them. Bail ultimately is the decision of the judicial officer to decide whether to grant or not to grant. Similarly, the terms set are also at the discretion of the judicial officer. Many times they set cash. They can request for cash to pay before release. They can ask you to deposit some key documents like passports or national IDs. Some people even ask for titles, either land titles of the accused person or for the sureties. All that is supposed to ensure that this person comes back.
Under what circumstances does court request for land titles?
The practice is usually for very serious offenses, and offenses usually which involve money. And of course, the thinking is that a person will fear to lose their property. That means that they will respect court and come back to attend, or they will be able to compel the accused person to attend. So usually it's those offenses which involve money or serious offenses. And even if the sureties are bonded on non-cash terms, this bond will only be executed if the accused person flees. So many times when court says sureties are bonded at 50 million non-cash, it means that if the accused person does not attend trial or escapes, this 50 million will be paid by the surety, failure of which the surety will be committed to civil prison. For an accused person, if it's cash, then the cash has to be paid on before release. We have to know, though, that at the conclusion of the case, of the trial, no matter whether the judgment has gone for or against the accused person, this money is supposed to be returned if it was payable in cash. There's a process for the person to apply for this money, whether you have been convicted or not. Since this money goes to the consolidated account, because it's banked, it's payable in the bank, there's a process for applying for this money by the accused person and getting it back to you upon conclusion of the case.
What happens if the accused person absconds bail?
If the accused person jumps bail, call it, or absconds from returning to court, the sureties are supposed to be either lose the money that they were bonded to, which they said that is non-cash, now it becomes payable. If you don't have that money, then the person, you are supposed to be committed to prison. And if you pay that money, then the court, of course, if you jump bail, will issue an arrest warrant. Then it becomes the duty of the enforcement agencies like police to ensure that you are arrested and you come back and attend your trial. Therefore, if you're a surety, your main role is to ensure that this person returns every time there is court. If you feel that you no longer have the power to compel the accused person to return, then you can apply to court to be removed as a surety. And if you are removed, then of course court cannot force you to be a surety. So if you apply, court will remove you and they will cancel the other person's bail until they bring a surety to replace you, who will also have to satisfy court that they are substantial. So if you feel that you can no longer satisfy or can no longer have a control over the accused person to return, you can always apply to court. Similarly, even an accused person who feels that the terms are harsh, they can always apply for variation of the terms. You may have deposited your travel document and now you have a genuine reason for travel. You can always return to court and vary the terms, and court can always vary. Court can cancel someone's bail if, one, there is an abuse of the bail terms. Sometimes court requires you to report periodically. So if you no longer report, they ask you to go to the registrar to report. If you no longer report, or you don't report as ordered by court, or any breach of the bail terms. There are sometimes when people say you're not supposed, these days those terms are common, don't supposed to travel within these districts. Your travel is restricted to Kampala and Wakiso. So if you breach those terms, court can cancel the bail on its own. Or if in the course of the trial, evidence is so overwhelming, even before judgment, court can cancel the bail without even a breach of the terms. Because there may be a fear that by the time judgment comes, you could have fled. So we've seen circumstances where court cancels someone's bail before the conclusion of the trial. We saw it in the case of Uganda versus Matthew Chirabo. We saw it in the case of Uganda versus Honorable Akbar Godi, where court cancelled the bail before the judgment, where it feels that evidence is so overwhelming and you might flee before conclusion of the case.
Sir,